Legally selling a house when someone's passed away, first, I'm sorry for your loss. It's always a very emotional time, and nothing has to happen immediately. Deal with your emotions, your family, make sure everyone's looked after. The grieving process can be very, very hard, can sometimes lead into depression. So you want to make sure just everybody is as okay as possible in these situations. When it's time to sell the property, then we're going to work with you to make sure that this goes as smooth as possible. The first thing we're going to look at is there just one person on the title, the person who's passed away, or is there more than one? In an incident where there's more than one person on title to the property, our next question is going to be look at the title and see if it says where the people's names are, is it tenants in common or joint tenants? If it says joint tenants, then the process is very easy. There's an affidavit that gets sworn. So basically you're taking a piece of paper, we'll prepare it for you. It's a very low cost, quick, easy solution. And the person swears that I am the surviving joint tenant of the property. We provide a death certificate as an exhibit to the affidavit. We send it to land titles, and property is just transferred into your name. It does not go into the estate. It's not part of a will. As joint tenants, you just get all of the property. That's the surviving joint tenant. Now, if it says tenants in common, or if there's just one person on title, or if it doesn't say either tenants in common or joint tenants, then it's deemed to be tenants in common, meaning that you have to go through the probate process. With land titles, there's no way around probate if a person's passed away and there's a requirement for probate in that situation. In those cases, then we have to do the application for probate or grant a letter of administration if there's no will in place, and that person's share of the property will transfer through to whoever they have named in the will. It gets pulled into the estate versus joint tenants, which never go into the estate at all. Once it's in the estate, then the family members can sell it. It can be distributed to the person who inherits the home, or if there's not a specific name for the person who gets the home, but one of the beneficiaries wants it, then maybe they just take that as their gift under the estate. So there's lots of ways that can happen, but probate is going to be key. And what that means is that the court says, this is the person who's allowed to sign things for the estate, this is the person who can manage things. Without that, nobody can sign anything. We often get questions from real estate agents where they say, hey, like this person wants to sell the home, they haven't got probate yet, can they sign? Legally, no. And so you want to make sure that you follow all the rules, because if you do sell it and there's a problem and you weren't allowed to by the courts, you can get sued personally instead of the estate being sued, because that you did something that you weren't supposed to do. Even in the contract for selling real estate, it says that you have a legal right to sell the property, and without that grant of probate, you don't. There are sometimes ways of getting around it, and your real estate lawyer will help you through it. We will draft things to put into the contract before it's signed in order to protect both you and the estate, and even the buyer, to make sure everybody's on the same page and we have a way of closing and going through. So there's ways of doing it, but we don't really suggest it unless we know for sure that there's not going to be an issue. The estate lawyers can usually tell in advance that they're able to do that. Now remember, if you are looking after somebody's home and you're legally going to be the person who sells that estate, house, or property, you've got to maintain it. That means you have insurance, that the mortgage is being paid, that someone is going into the house every couple of days in compliance with your insurance rules, that the locks are safe and secure, that the alarm is set, all those things to make sure that the asset is protected. Because we know that can be an expensive and challenging thing, we want to make sure that the probate process is started right away. And in situations where we can't do the quick probate process, that we apply for a limited grant to probate, and that is explained in another one of these videos, and there's a whole page dedicated to it if you want to find ways of making probate go faster. The last question people ask, though, is what about like estate taxes or capital gains? Now, typically, this is something you work with the accountant with, not the lawyer. If it's a principal residence that's being sold, then typically there's not a capital gain. And Alberta, at the time of this video, there is no estate tax per se where the government's taking a certain percentage of the assets of the estate. In Alberta, it caps out. It's a reasonable number, so it's not a terrible thing. But again, you're going to work with your estate lawyer to make sure that's done so that when you legally sell the house, you're not causing problems for yourself or the estate.